Can you see the screen?
Not yet.
Sorry.
Okay, we can see your screen now. Yeah.
Okay. A very warm welcome from Singapore. My name is Kelvin. I'm a partner at the law practice of CMS. I also head up the construction infrastructure practice group, and we cover contractual and legal issues arising from construction and infrastructure projects, not just in Southeast Asia, but in the larger part of Asia, including Korea, Japan, and parts of China as well. I'll just outline the talk that I have prepared this afternoon. It won't take me very long. Basically, I have three sections that I would go through with you. The first section will be about a common law system that we in Singapore and Malaysia operate under, which is very different from the civil law system that Vietnam operates under. And then I will move on to the type of protection that the common law systems give to contractors and subcontractors in terms of cash flow. And I will also touch upon some protection that contracts will also give. Some of these items that I will be talking about may cross over with other speakers, but we can obviously imagine that the topic is intermingling, and it's also a good way to cross-fertilize and have questions asked of us. So without much further ado, I will move on to the first section, which is the common law system that we have. Well, unlike Vietnam or other parts of the civil law system, Singapore and Malaysia, we gained independence from the United Kingdom in 1963, and Singapore gained independence from Malaysia in 1965. So we only have about 50 odd years of independence. So the legal system that we operate in is very much based on the common law system borrowed from the United Kingdom. And a lot of the laws that we started off with came from that system. Just very briefly about the common law tradition, we essentially have two types or two sources of law. One is by legislation from the government. We call these ordinances or statutes. Then the other source of law are judge-made laws. Basically, judges are entitled to create precedents in their decisions, and the later cases will have to be bound by earlier cases on the same fact scenarios. So that's basically the common law system that we operate in. And of course, you know that the common law system operates also in other parts of the Commonwealth, which is countries like Australia, Canada, to a certain extent the US, Hong Kong, India, and the likes. Now, coming to the issue of protection of contractors and subcontractors' cash flow. At least in Singapore, in the 1990s, we have very similar issues that you are facing right now, which is that we see a very sharp rise in the insolvency and bankruptcy of subcontractors in the market. And that is not a very good sign for the industry, because these are the arms and the legs that supports the industry. And so the government went searching for some remedies to help to sort out this situation. Obviously, we can look at contracts to help each other, but not all contracts are going to be executed in the same manner. And especially for subcontractors, sometimes you just have to sign a contract in the way it is. There is no way to amend or to negotiate the subcontract, only because you are a subcontractor and you just take the contract as is. So essentially what happened in Singapore is we took inspiration from the United Kingdom, which came out with a statutory adjudication scheme in 1996 under the Housing Grants, Construction and Regeneration Act. We enacted similar provisions from that source as well as the Australian source in 1999. And we came up with a statute called the Building and Construction Industry Security of Payments Act. And this was enacted in 2004. A couple of years later, in 2012, Malaysia also came up with a similar statute. They call it the Construction Industry Payment and Adjudication Act. That's dated 2012. And if you run through some of the common law jurisdictions, so far, I think the jurisdictions that have similar statutes protection are in the UK, in Australia, and I'm just making reference to New South Wales just as an example, but all states will have theirs. New Zealand also has a Construction Act in 2002. I think the New Zealand Act was the one that Malaysia took inspiration from. Canada has just introduced the Act in similar fashion in 2019. And as I understand it, Hong Kong is currently looking at enacting a similar Act. But as you know, Hong Kong is subject to a different regime in the future, so we are not sure how far that is going to go under Chinese rule, but that's the Hong Kong situation. The main purpose of the Act is to recognize that a person who carries out construction work or has supplied goods and services must be entitled to progress payment. I think that's very clear. I think everybody believes in that, but not everybody practices that. So it is always good to have a statute that says that in no uncertain terms. And the purpose of that is to create a norm, a practice within the industry so that everyone understands that this is the very basic denominator that we must operate under. If you have done some construction work, you must be paid. And similar provisions are also found in the Malaysian Construction Act called the SEPA. It says, an act to facilitate regular and timely payment, to provide a mechanism for speedy dispute resolution through adjudication, provide remedies for the recovery of payment in the construction industry, and to provide for connected and incidental matters. Now, what does this all mean to all of us? It means that you have your subcontract or main contract that is signed, but on top of that, the law will provide another layer of protection through this statute. And that protection will afford speedy recovery of payment if the main con or the employer refuses to pay for any reason. Now, a simple process based on the Singapore SOPA Act is set out in this slide. Essentially, you're looking at a very speedy dispute resolution process of only 45 days. So if a subcon makes a payment claim and he does not receive payment, or he doesn't receive a response as to what his payment figures is going to be like, he is entitled to put forward an adjudication application, which what we call AA in the red box in the middle. And within the span of 21 days, he will be able to get a determination or a decision from a tribunal called an adjudicator. And that decision will be enforceable like a court judgment. So he can in fact run to courts and he can enforce that as a debt against the main contractor in the same way as a debt. And similarly, if the main contractor chooses to operate this system, he can also make an adjudication application against the employer. So essentially, you don't have to wait for payment. If payment is not forthcoming, you just implement the system, and 49 days later, you will get a result. Now, a couple of things that I heard my previous speaker, Mr. Kwan, say, which is very true actually, and that is, how are you going to ensure the practice of back-to-back nature in your industry is regulated? So a couple of features in this act which may be of interest to the Vietnamese community would be as follows. Number one, pay when paid provisions in contracts will have to be prohibited, which means that a main contractor cannot include in the subcontract a clause that says, I will only pay you if I get paid by the employer. And even if such a clause exists in a subcontract, that clause will have no validity in law. I think that is very important because for this whole system to operate, we must create a norm or a practice where we don't just pay when we get paid. we have to be responsible to pay when the work is done. I think that's the first feature of the statute. And the second feature that I thought I should mention is this handicap system in the adjudication proceedings, where, for example, if a subcontractor makes a claim and the main contractor doesn't give a reason as to why he is not paying, and then the subcontractor proceeds to adjudication proceedings. Now, the main contractor, because he was silent at that point in time, he will lose the right to raise any reasons that he has not raised before in the adjudication proceedings. So this creates a handicap on the main contractor. So if he wants to avoid payment, he must state the reason for why he's not paying. Or if he's going to pay short, he needs to tell the subcontractor why is he paying short. Is it because the quantities claimed is excessive? Or is it because the rates that are supplied by the subcontractor is wrong? He must say that, he must inform the subcontractor why. And if he doesn't, he cannot say it later on. So in that sense, in a situation where the main contractor keeps silent, it is quite clear that the subcontractor will have quite an easy route to get to a determination under adjudication. And so he gets his payment. And the third feature of these statutes across most jurisdictions that after you get the adjudication decision, it is enforceable in 4 ways. Number one, you can obtain direct payment from the principal. So for example, if the subcon obtains a positive result from the adjudication and the main con still doesn't want to pay, the subcontractor can write to the employer and request for direct payment. And then the principal or the employer will then decide if he does want to pay directly, he will then subtract the payment that he's paying directly to the subcontractor. He will deduct that from the final accounts of the main contractor. The second feature would be a security, or what we call in common law the lien, on goods that is supplied. So essentially, the subcontractor still holds on to the ownership of the goods that he supplied until he gets paid, then the property passes over. The third feature for enforcement is that the subcontractor can straight away suspend works. It doesn't mean that he can suspend works immediately during the adjudication, but he can only do so after the adjudication result in his favor is obtained. And he can give notice that, look, I'm not being paid, I've went for adjudication, I've got a positive result, and I'm still not being paid, so therefore I have a right to suspend works, and I'm not going to be in breach. And the fourth, as I've mentioned earlier, is that there will be an enforcement of that adjudication decision, like a court judgment. So if you can freeze a main con's bank account or project account, likewise, you can use this adjudication result to freeze the project account of the main con, such that every regular payment that comes from a client will be diverted to the subcontractor. So you can see that the statute is quite far-reaching, and it has created a whole system of jurisprudence around this, and it has in fact created an industry norm in Singapore and Malaysia as to how and why and when you should expect payment. Now, the last topic I want to talk about is protection by contracts, which is quite common. You all use a lot of international forms, and some international forms are set out in the screen that you see. The most common one that you would have come across would probably be the FIDIC or the NEC. In the UK, there's also the Joint Contracts Tribunal form, which is called the JCT. And in Singapore, there are the Singapore Institute of Architects form, the Public Sector form, the Readers form. And in Malaysia, there is the PAM form and the JKR form. All these are essentially bifurcated by whether it's public sector or private sector. And just look through most of these forms, you will see that there are some standard features that you see in all these forms. In a small way or the large way, they are usually to be found in these forms. The first one will be the contractor's right to progress payment. I think that is set out in all the standard forms. There is a right to be paid. Whether it's by monthly payment or by milestones, it will be paid. Number two, there will be consequences of late payment. Normally, it will be by way of late interest, but in some contract forms, it goes further to give the subcontractor a right to suspend or even to terminate if the late payment is beyond, let's say, 180 days. Now, the third is an issue about whether the risk of the materials the subcontractor has supplied has passed. Because you know that when you provide materials onto site and it lands on the site, the legal ownership of that sometimes passes to the main contractor, even though the subcontractor has not received payment. So there are provisions where you can play around with when and where these risk and ownership of these materials should pass. Fourth, as was mentioned earlier, the use of bank guarantee or performance bond has now become quite commonplace, and it has replaced the need for security deposit by cash. So that is a very common tool that main cons and subcons in fact use against one another. Fifth is the holding of retention monies. It's a very old concept. At the end of every progress payment, you retain up to 5%, and at the end of contract, up to 10 or 5% of the contract value. It is a very old practice, but the existence of retention monies, in fact, compromises the cash flow of contractors. So at least in Singapore, what the government has done is we have done away with retentions. We no longer require retention monies to be withheld by main contractor or by the employer under the public sector projects. What the government will require, although, will be an issuance of a larger amount of bank guarantee or performance bond to cover retention monies. Or sometimes they would recommend retention bonds to replace the need for retention monies. Of course, there's a right to seek adjudication under the Security of Payments Act under both jurisdictions. And if that fails, of course, there is still the usual dispute resolution provisions for mediation and arbitration in these standard forms. So there's certainly protection under the contracts. What we are saying is that the statute will bring about an extra layer over the contracts, and that has proven to be very effective to manage the conduct of main contractors and subcontractors insofar as it relates to payment practices. That's all I have, and I'll happy to take questions if you are minded to ask eventually. Thank you.
Okay, thank you, Kelvin. Short but good enough. Brand new to us, to the audience in Vietnam right now.